Okay, looks like the majority of the people have joined, so I'm going to start to be conscientious of everybody's time. If you're familiar with the virtual Zoom capabilities and functions, if you have a question, you can pop it into our Q&A or our chat box, and I'll be able to answer the questions as we go. At the end, I'll also be able to provide my contact information, so if you have questions about this training, please let us know, and I'll be reaching out to everybody to provide them with this training recording as well. Today, we'll be learning about Family Medical Leave Act and how to manage it, who needs to pay attention to it, and all the magical details that are required under the federal guidelines. We do always have to be encouraged by our lovely attorneys to disclaim that we are not attorneys, we are not providing legal advice or any kind of payroll or anything like that advice, but our information is to be used as educational purposes. All the information we are giving today has been provided directly from the federal government, so I assume that everything will be accurate. But as things change, paying attention to any kind of updates, we need to make sure that we are protected and protecting you. My name is Toni, and as I said, I'm the co-founder and owner of Bluelion. And here we go. So today, some of our objectives are to go over high-level history of FMLA, who has to offer it as an employer, who can request it as an employee, what is qualified leave, some different definitions of who is qualifying for what, how to process it, not an exact step-by-step, but pretty close, documentation you can request and is needed, basic provisions, and then areas to be careful of. FMLA can sometimes be a trigger point for certain discrimination cases because it can also run so concurrently with the Americans with Disabilities Act, short-term disability, other state leaves, and we'll talk a little bit about how that all works as well. So FMLA, what is FMLA? So FMLA is the Family Medical Leave Act of 1993. It is a federal law, so it covers the entire United States of America, all 50 states. It's not state specific. Some states, of course, do have a little bit more strict leaves that also are more protective than Family Medical Leave Act. But the Family Medical Leave Act is at least the minimum requirement if they don't have a state specific leave. It requires employers to provide employees job protection, unpaid leave for employees that qualify based on life circumstances. We're going to talk about what those are. And it allows for 480 hours or 12 weeks. And that is, that's 8 hours a day at 5 days a week, 12 weeks of job protected leave. Employers can select different ways to look at leaves. Some employers will go calendar year, January to December. Some may look at their fiscal year. If a fiscal year starts in June, it'll go June to May, and then some go for a 12-month rolling look back, which is of course something that I always really prefer to do and suggest. And the reason for that is if you do a calendar leave, I cautious people that, let's say I take leave at the end of a year, October, November, December, I'm taking 12 weeks. Well, January 1st, if you do the policy that way, the leave comes back again. So I could take another 12 weeks continuously. I could have 24 weeks out of protected leave because of how the definition of your calendar year works for FMLA. So I like to do a 12-month look back upon the date that the employee needs the leave. I take that date and I look back at the previous 12 months to see, have they used any kind of FMLA? That will then let me utilize how much they have left. The 480 hours allotment is prorated for part-time employees. A lot of employers don't know that part-time employees also qualify for FMLA. They would just qualify at their 12-week of their regular standard hours worked. So that is a proration on part-time employees. It is essential for managers and supervisors, as well as owners, as well as HR, whoever's really working with the employees directly, to be familiar with how FMLA works. A lot of times we have seen in the HR industry where a manager misreads a situation, an employee has said, oh, I have a surgery coming up or something like that. And the manager, instead of saying, okay, here, you need to contact HR or the benefit team or whoever it may be to process your Family Medical Leave Act, see if you qualify, they forget to do that. And then what happens is they go out on leave, maybe their leave gets extended, 2, 3, 4 weeks, depending on the surgery. And then the employer gets frustrated because they're not qualifying it as FMLA. They didn't think about it as FMLA. And then maybe they want to terminate the employee. And there comes a lot of different legal issues with that. So making sure that your supervisors, in addition to whoever your HR staff may be, whoever is managing your human resources, and letting them know what FMLA is and how to manage it and what some of those trigger words are. I need a surgery, I'm having a baby, my wife is having a baby, whoever it may be. I have a child who maybe is in and out of some kind of long-term care, a parent who needs something. I have a significant other who is about to go on military leave. Just these little keywords can help them be aware, oh, okay, maybe they don't know everything, but they know that they can get the next person in line who's going to be able to inform the employee of what their rights are under FMLA. It's also important to know that FMLA can indicate the need for Americans with Disabilities Act to kick in. We see this heavily when we have chronic illnesses. So people, for example, we've seen who have heart conditions, who have had strokes, who have had limb issues. So if you've had some kind of a surgery, we've seen with diabetes, if maybe you've lost a certain body part, a foot, things we've seen like that, there can come accommodations. And sometimes an accommodation can be extending FMLA past that 12-week time frame. So again, it's very important to recognize that in the alphabet soup, a lot of different leaves can come into play and a lot of different legal actions can come into play as well. So training your employers, making sure your managers know these are just the words to pay attention to. Get me or whoever's in charge of this particular process, if you hear them, will help you stay compliant and not have to worry about certain claims of discrimination. So what employers are covered by FMLA? A covered employer is one of the following. For the private sector, it's employers with 50 or more employees. A lot of employers ask, okay, well, I had 48 and then I had 51. How does it work? So private sector is 50 or more employees in 20 or more work weeks. So that is important language. A lot of industries maybe have shutdowns for certain times of the year, manufacturing or other things. So paying attention to what a work week is. And in the current or the preceding calendar year, including a joint employer. So if you're a joint employer, which is generally defined as if you have owners that own 80% or more of the business and a second or third business, even if business number 1 has only 15 employees, business number 2 has 20, but business number 3 has 30, collectively you have hit the FMLA required guidelines. So you have to offer all 3 businesses in the joint ownership the availability to use FMLA. So it's important to recognize that as well. Public agencies, including a local, state, or federal government agency, regardless of the number of workers employed, so they hit threshold at 1 employee. And then public or private elementary or secondary schools, regardless of the number of workers it employs. So they don't have that threshold of 50 employees either. So what employees are eligible for leave? Well, before you even get into what they need to leave for, do they qualify? So employees must have worked for the employer for 12 months. It's important to recognize that it's actually not consecutive months. So if I leave employment and come back, it's 12 months non-consecutive, and then they allow you to find the periods of employment spanning over previous 7 years must be combined for that timeline. So if they worked for you 20 years ago, you're a longstanding employer, they come back, that doesn't count. But if they've been on and off for you because maybe they're seasonal or whatever may happen, part-time, on and off, they could qualify. So paying attention to that timeline is very important. And they must have worked a total of 1,250 hours within the 12-month period before the leave. So this can't be spanned out through a 7-year time frame. This has to be the previous 12 months from the date that the employee wants and needs the leave. So that's the second piece as well. Then they have to actually have a qualifying leave in order to be approved. So here are the 6 major leave reasons that an employer is allowed to give FMLA to an employee, which is for birth of a child or to care for a newborn child, for placement with an employee of a child for adoption or foster care, to care for employee's spouse, child, or parent with a serious health condition, because of a serious health condition that makes the employee unable to perform the functions of their job duty, because of a qualifying exigency arising out of the fact that the employee's spouse, child, or parent is a military member on covered active duty. There's very specific language on what that may be. But if you have someone on military who needs military leave, looking into those specific actions is very important to make sure you're in compliance. And then to care for a covered service member with a serious injury or illness that is a spouse, child, parent, or next of kin who was a service member. So military has their own 2 specific reasons out of the 6, and the other 4 is generally for yourself or for a direct family member. Now, the government does actually define what a child is consistent of. So today, now more than ever, there are children being raised by not their biological parents. They are being raised by grandparents, they're being raised by aunts and uncles, whoever that may be. So even if you're not a biological parent to the child who's having a medical condition or is being placed in your home, you still would be able to have that time depending on what the qualifications are for them. So the language is very specific, allowing for the NOLO parent, which is somebody who is not biological but taking care of a child, to be able to have the leave as well. I love this meme because it reminds me of a funny joke I saw on The Office where people think that they can take leave of absence for a pet being placed with them. Pets are not qualified for Family Medical Leave Act. You can't take cat-ternity or dog-ternity. Maternity is generally a standard thing, or paternity. So it's a fun little thing that I added. So how does FMLA help employees? And that's really the main purpose of FMLA when it was designed by the federal government. It allows the benefits to be maintained. So while an employee is on a leave of absence, if you're an employer of 50 or more employees who is required to offer FMLA, you're also currently required to offer the Affordable Care Act. So you have to offer affordable health insurance. Well, if I'm on a leave of absence, my benefits get to stay active. I don't get terminated for my benefits or co-bred for my benefits in that 12-week time frame. It protects an employee from disciplinary action for using approved FMLA leave. It does not protect the employee from receiving disciplinary action for any kind of act or issue which may have arisen during the leave but happened because of the employee prior to the leave. So sometimes people get really nervous when they have an employee who goes out on leave who maybe has had some performance issues. How do they manage that? You can absolutely manage it. There is a specific way we encourage doing it, gathering the information while on leave and then addressing upon return to work. So you don't really want to at any point in time engage with the employee on performance-based issues while they're away. It would be considered working. If they're working, they're not taking leave, you would have to pay them. So paying attention to that. But there can be disciplinary action that occurs upon the return from the leave, as long as it has nothing to do with the reason that the person took the leave of absence. So that's one thing that I know a lot of employers get worried about. They have a troublesome employee, all of a sudden that employee needs leave. Maybe they were in the process of thinking about terminating them. What do they do now? It's definitely a little bit slippery. So reaching out to your labor law attorney, an HR consultant, somebody in-house who's really knowledgeable in that process to make sure your bases are covered on that. It holds the employee's position during the absence for up to 480 hours or the 12 weeks, which means they have to be able to come back to their same job or almost exact same job if the same job no longer exists, as well as their same rate of pay and their same benefits, unless there has been a major change in the business. So for example, we've had COVID within this past year. So a lot of employers maybe have downsized, maybe they have reduced their rate of pay for certain jobs. They did layoffs and brought people back. Layoff is not FMLA, but if someone was on a leave during that process, if they came back, because the entire business has made a shift that is not in relation to the leave that the employee was taking, you can make those changes as well because they are business need driven. Allows the employee flexibility in absence from work. So this is 12 weeks consecutive. So Monday through Friday for 12 consecutive weeks. Intermittent leave taken as needed. We see a lot of intermittent leave if people have significant others or children who are maybe dealing with serious medical conditions that need to be in and out of the doctor's office. Maybe they don't need to be home full time with them, but they do need to take them maybe in and out of chemotherapy or something. So they need to be out maybe 1 or 2 days a week. So that's intermittent leave. It obviously extends timeline, but they do not get additional time. They still only have those 480 hours to use. Reduced leave, which allows the employee's normal schedule to be adjusted to accommodate the employee's limited ability to work. So again, let's say all of a sudden employees have to do specific therapy or rehab. Your normal schedule is Monday through Friday, 8 to 5. If at 3 o'clock the employee has rehab, so for 2 hours of their day, 2.5 because there's travel time, those 2.5 hours every day would be a shift in their schedule, but it would be considered a reduced leave. So they're taking a little bit of hours every day and covering that. But it is important to realize that they still need to be able to perform their job functions when they're on those kinds of leaves. So if they're having their own serious medical condition that would prevent them from being able to do their job, you can mandate based on certain requirements that their leave be consecutive. That's very specific to your industry. You know, if somebody's doing manual labor versus working in an office setting. So paying attention to that is really important. Processing FMLA is usually pretty standard across the board. There might be a few extra things here and there depending on what state you're in, or if your company offers short-term disability, or if you have paid time off. But on average, the process is almost identical because everyone needs the same paperwork. So it usually goes something like this. The employee informs the employer or a manager that they need a leave of absence. It can initially come verbally. Always have the employee put in writing that they need the leave. A leave of absence form is something you can find on Google, something we can obviously provide to you, but it's important to have them fill out what they need. Is it intermittent? Is it leave for themselves? When is it? Is it tentative? You know, some people can know exactly the date they need to go on leave because a surgery is scheduled. Maternity sometimes is a little bit harder unless they also have a C-section scheduled. So some are tentative and some are nailed down in stone. HR, I put in quotes because whoever's handling, again, that function provides the employee with the federally required paperwork depending on the type of leave. So is it leave medically for themselves? Is it leave medically for a significant other, a dependent? Is it military leave? So those are the 3 major ones that have documents that need to be collected. So whichever those ones are, you would provide to the employee. HR reviews the employee's personnel file, again, to make sure that they're eligible. So even if you're an employer that's eligible to offer it, not every employee may hit it. So paying attention to that timeline, of course, and seeing when they're eligible and if they are eligible. Employees provide then the medically required documents back to HR that you provided them. They're their certificate of health generally. You review the document for accuracy and total completion. Almost every single one of those documents, 2 out of 3 is provided by a medical professional. The third is the military one. You generally get military orders that tell you if somebody is going to be needing to take a leave to go to active duty. So you're looking just to make sure that they've checked off the necessary boxes, saying that the leave is medically required, whether it's consistent or whether it's not consistent. That's the intermittent or the consecutive leaves, and what the needs are of the timeline. So then you're evaluating the validity of the leave. It's very easy to do because again, the medical employer is saying that it's whatever is going on. HR provides the employee with the required FMLA documents, either denying or approving the leave. Again, are they eligible for leave? Great, that's the first thing to check off. Did they give you the proper paperwork and it's all accurate and complete? Then they're likely going to be approved. Maybe they haven't worked for this period of time, or maybe the medical paperwork is incomplete. So at the point at that, you say it's denied, you need more information. HR notifies the employee's manager. This is a big one. Sometimes employees will talk to a manager and not the HR person, or the HR person and not the manager. You want to make sure everyone's on the same page, but you also want to be very conscientious of the confidentiality. Just because you, as the coveted HR function, has access to the employee's medical information, it's still covered under HIPAA. You don't really want to share that information with anybody else in the business. You don't have to unless it's absolutely necessary. So just letting the manager know, excuse me, that the employee is going to need to leave for themselves or for a significant other or a dependent, and the timeline that they need it. If there's any additional information needed, Again, going back to the ADA piece for an accommodation, that will become an interactive process. But most leaves are generally 80% standardized. Upon a return to work, everything is good to go for them to be 100%. The employee or the manager informs HR that their leave has begun, usually a phone call if it's maternity, an email, whatever it may be, and then you start tracking the leave. So it's easy if you have a payroll system or an HRIS that does this for you. If not, it can be as easy as using an Excel spreadsheet, putting the first day of the week, the last day of the week, and how many hours have been used, and then tracking it down to 0. It's important to know that if you have short-term disability, this runs concurrently, so you'd always want to give the employee the same paperwork. So if they're going out on a FMLA and they're going to have their own serious medical condition, short-term disability, if it's something your company offers, would kick in, depending on how long they're out for. So providing that information to them to complete is great. One thing I see often, which is a mistake sometimes, is an employee says, oh, I only need 2 or 3 weeks of leave. And so an employer's like, I don't want to really put up with the FMLA. You kind of do. So the reason I always encourage that is because if you forget to track now and you're going to just consider it a personal leave and you're going to quote unquote wash it, if they need to leave later on, that 12 weeks is still available to them because you didn't actually process a full FMLA leave. So even if it's a few weeks, still process it if it qualifies. Chances are good that they still are going to be able to collect all the paperwork needed, and it keeps you informed on exactly what's going on throughout the entire organization. Some state leaves also require a different leaves. So some states have a stricter, as I said, FMLA policy. It's a state leave policy that may require an employer to pay. For example, Massachusetts has the paid family medical leave, which allows employers to pay tax into the state. And then if an employee needs a leave of absence and qualifies very similarly to FMLA federally, they're able to get pay through the state. Some employers in the state of Massachusetts have decided to do that on a privatized way. So they'll work with their guardian or a direct carrier to run that process for them. But paying attention to your state to make sure if there's state leaves, they all run concurrently. And then of course, time off. If you offer time off, having or requiring your employees, does your policy say that they have to use it when they're on leave or not? The only time you cannot mandate that employees use time off is if they themselves have been called to active duty. If they're taking care of a significant other or a child or a dependent, again, a parent who has been called to active duty or who has an injury or illness, that does not qualify. You can mandate the time to be used for that. HR collects any additional paperwork throughout the leave. Sometimes leaves will need to be updated every 30 days or so, depending on what the major medical issue is. So there could be additional medical paperwork to collect. If you offer benefits through payroll deductions, you would invoice your employee for anything missed. I've also seen employers, if they've been given enough notice ahead of time, do double payroll deductions upon right before they leave or double deductions upon return. So either way, just making sure your process is the same, making sure you're collecting those deductions to keep the employee active and making sure their benefits don't lapse. The employee will inform HR of their return to work. HR will collect any return to work notice. If the employer had their own medical condition, you want to make sure they've been cleared by a doctor to come back full duty, or if there's accommodations, you'll want to know what they are. And then of course, you'll communicate that with the manager. And then the employee returns to work. I always encourage auditing the leave about a month after the fact to make sure everything has been buttoned up and closed down. A little space from a leave can sometimes remind you, oh, I forgot to put that in the system, or I didn't do the audit of the invoicing for benefits, whatever it may be. By giving just a couple of weeks or even a month, looking back, reviewing that you have all the paperwork, using a checklist and closing it out, just make sure that you have everything, all your I's dotted and your T's crossed. A lot of states, as I said, do have concurrent leaves. So for example, Massachusetts, New Hampshire, Maine, all have additional leave called maternity leave, which kicks in at 6 weeks, employees, I'm sorry, not 50 employees. So paying attention to maternity leave, you may be qualified to offer that to your employees before FMLA. But if you think that there's an employee who has a medical condition, as you can see here, you definitely want them to take the leave. You don't want to keep them coming into work, especially if it could create long-term medical issues. You don't want something that is a medical condition that is private and happened outside of work to turn into a possible workers' compensation claim. So paying attention to that is really important. Documentation. From an HR standpoint, I know it's a headache for a lot of employers, but for HR, it's obviously one of our strongest suits to protect against liability or discrimination claims. And here are the most common ones that we really track. So the request for FMLA, usually that's a standardized form provided by somebody in-house. Again, it says their name, what's their position, how long they worked there, what do they need the leave for, is it their own serious medical condition, family member, military, is it consecutive or is it going to be intermittent? And when you get that, you then look and see, okay, they need one of the following few notices. So the certificate of healthcare provider for employees, serious health condition, you give that to them if it's their own condition. The employee must provide a completed certification to you within 15 calendar days. So FMLA does provide very specific leave requirements. The reason I tell people that is because FMLA really tries their best to ensure people do not abuse leave of absence. And so in order to do that, they provide a timeline both to the employer and to the employee for paperwork to make sure that everyone is really doing their due diligence, communicating with the necessary medical professionals, and communicating internally. Their certificate of healthcare provider for a family member's serious health condition, same timeline. And then, as I said, there is the military leaves. However, there is not paperwork provided to the employer from the employee from the employer. That paperwork will come from the military. They're going to give you paperwork that says somebody has been called up to active duty, the timeline, the exact dates. It is very thorough. I joke it's one of the few times the government is as thorough as they probably could be. So that paperwork just needs to be provided to you so that you can provide the leave information. Upon getting that paperwork, you need to provide back the designation notice. You as the employer have to notify the employee of their FMLA eligibility within 5 business days of getting the first leave request. So generally employees can do both, give you the request and the certification depending on how advanced they are. If not, you can always provide the paperwork, and it's a government document. You don't have to create it. Neither do you have to create the certifications. And you just check off more information is needed or additional documentation is needed, which means the leave can't currently be approved. But as soon as you get all the paperwork, you just provide another designation notice. So each time additional information comes, the time period starts ticking as well. The notice of eligibility and rights and responsibilities, another government form, has to go at the same time as the designation notice. So you'll send both of them out. That document just lets employees know about their leave, whether you do the rolling, the calendar year for the 12 weeks, so on and so forth. It also lets them know if they need to use their time off or if they have any additional kinds of payments that are coming to them, whatever it may be. And then the last document required, I say, for tracking is the fitness for duty certification. So making sure that they've been cleared to return to work if it's for their own employee serious health condition. You want that to be as thorough as humanly possible, especially if you have employees who do manual labor work or an employee whose leave may affect their ability to return to work. The reason for that is if you require employees to stand for long periods of time and whatever their leave may be, they can't stand for longer than 3 or 4 hours, but they have 8-hour standing shifts. You're going to want to make sure that it says that on the fitness for duty report so that the primary care physician or the surgeon or whoever's filling that out recognizes that that is a bona fide qualification of the job. Otherwise, like I said, it might be a short-term ADA, Americans with Disabilities Act situation, and we would have to monitor that as we go. If they're leaving for their spouse, a significant other, you wouldn't need a fitness for duty report because they're fit when they left, they'll be fit when they return. So here are some additional basic provisions of the FMLA. Federal FMLA, Family Medical Leave Act, does not require the leave to be paid. Again, some states may have different backgrounds or state laws, but the federal government says the leave does not have to be paid, which also means they don't have to take, PTO if you don't want them to, whatever it may be. The law allows employers to require employees to use any paid leave that they may have. So if you do have a leave of absence, a PTO policy, you get to make that mandate, saying that employees have to use all their time up before they, go negative or zero while they're out on a leave. One thing I tell people about that process is at times, if you offer short-term disability as well, is it can prevent short-term from paying out, because if they're collecting, let's say I have 4 weeks of paid time off, I'm only going to be out for 3 weeks. Usually there's a waiting period there before I can collect short-term disability. Let's say it's 7 days. If I didn't have any time off, I would be able to collect 2 weeks of short-term disability, which is on average 60% of my pay. But I do have time off. So for 3 weeks, I'm getting paid 100% of my pay, which generally means short-term will not pay the employee. So it does try and help prevent from double dipping, which is nice. The law also allows employers to use their paid time off during their FMLA leave if the use of the PTO would meet normal requirements. So again, what does your policy say? If your policy doesn't say anything at all, I suggest looking at it and updating it. If it says something that you haven't been following, again, look at it and update it. And if it says something that you are following, awesome. Provide that information to the employee upon the request for their leave. Employees requesting FMLA leave must provide verbal or written notice of their need to the employer. Again, within 5 business days after the employee has provided this notice, HR will provide the employee with the eligibility of rights and the designation. When the need for leave is foreseeable, they have to give at least 30 days. If it is not foreseeable, which sometimes we see that happen, if it's a major medical issue that might pop up, or if you've been injured, you went skiing over the weekend, we're in New England, it's beautiful in the winter, you broke your leg, you're going to be out. Those are unforeseeable things. Babies, generally foreseeable. Foster care, not always. So 30 days notice at least. Anything less than that, of course, would be unforeseeable. So they would need to provide leave same day or next day. As I said, if the need is not foreseeable, they need to provide the notice as soon as possible and practical so that the employer can make that decision. And then within the 5 business days, after the employee has submitted the appropriate certification, you'll provide that response to them. So again, the initial email or phone call or document gets 5 days. If they haven't provided the certification, letting them know that they need to provide that to you, and then providing them the final designation of approved or denied based on all the paperwork that has been gathered. It's important when you give employees the certificate of health for themselves or for their family member that you let them know they have 15 days to return it to you. Always put that in writing, just so everybody is aware of what that deadline and timeline is. Here are some key employer requirements of FMLA. Notify employees of their rights. Every employer also is required to have the FMLA poster. This is usually provided by a payroll provider. Or you maybe are handling that yourself, you're Googling and buying it on Amazon, whatever it may be. We also can provide that to you if it's something that's needed or necessary, but it is a poster that tells employees how FMLA works. Obviously providing them the FMLA paperwork when they submit it to you, letting them know of what their rights are. Outlining it inside your company handbook is super important, or having an FMLA policy standalone. You have to continue the health benefits at the exact same level as they were before the start of the leave. Something to pay attention to is if your employee is on a leave during open enrollment, you do need to communicate with them about the open enrollment process, and they do need to tell you what their new plan is going to be. So that you can make sure that they get that updated information in, and it will likely adjust the deductions. So just making sure you're communicating that as well. And then reinstating the employee to the same, or as I said, equivalent position upon conclusion of their leave. The only asterisk I had said to that earlier was. If there's major business changes or shifts, as we've seen in the last year and a half with COVID, bringing them back might not be exactly the same, but there's been major business shifts, so it's not discriminatory based on the reason or the person who is taking the leave of absence. Here are a couple of things to prohibit employers from and prohibit supervisors or managers from, especially interviewing managers. Making pre-hire inquiries requiring need of FMLA. So if you're in an interview, don't ask an employee, oh, you know, are you expecting to have a baby in the next year or whatever it may be. Don't ask any kind of medical conditions unless it's, here's the job description, can you complete all of these functions with or without an accommodation. Asking employees for a doctor's note for each use of intermittent FMLA. The government is very, very specific on this. I know a lot of employers are worried about intermittent leave because they think it's abused. Quite often people call out sick, you can't get medical notes every single time. You can have every 30 days recertification, however, for somebody who needs an intermittent leave. But if it's a day here, a day there, I managed an intermittent leave once due to gout. The gentleman would wake up on a day and he wouldn't be able to walk. If I asked him for a doctor's note every time, it would have been painful for him. And it's just not the culture I think that a business is really trying to push. If you do think somebody is abusing FMLA, there are definite processes to go through to make sure that that doesn't happen. But asking for a doctor's note is one of the no-nos that the FMLA kind of stipulates. Interfering with an employee's rights. So this is if an employer or a supervisor says you can't take your leave, even though it's qualified. Retaliation against an employee for using the leave. And then managers and officers violating the requirements of an FMLA. So it's important, and I write this in here because it is a legal action, that the FMLA uses the same definition of employer as the Fair Labor Standards Act and includes any person acting directly or indirectly in the interest of the employer. So even if your HR team is handling everything right, if you have a rogue manager who's going off or doesn't know the process and is maybe doing something, manipulating an employee's schedule, or retaliating, they are acting on behalf of you as the employer, and they are putting you and your business at risk. So making sure, again, that you're training employers, your employees and your managers on what is and is not appropriate. Your employees will know what they can take leave for. Your managers will know how to process when that information comes and reduce any kind of liability that could possibly exist. So in conclusion, what are we looking at? FMLA is a federal program, so everybody has to follow it if there are 50 or more employees. It grants employees 12 weeks protected, or the 480 hours, or prorated if they're part-time, leave of absence, protected job, not paid. Again, pay attention to your state-specific ones if you have a state that has a specific policy like Massachusetts. FMLA runs exactly concurrently with any kind of short-term disability, state leave, or time off process. There is required documents to keep track of and to make sure that you're following the legal process accurately. Everything but the request and the fitness for duty are provided by the FMLA on the Department of Labor. And be cautious of asking more information than is really required or needed from the employee. If you're giving paperwork and you have questions about it, work with your insurance carrier, work with your property and casualty carrier to see if there's additional information that might be needed, or if you feel like there may be a second opinion because you think someone's abusing it. But don't just ask for additional information that's not on that paperwork. The paperwork, again, is designed by the Department of Labor, Federal Department of Labor, to make sure that you're collecting all the necessary paperwork required and that you're gathering all the information needed. Now is the time that if you have questions, you can pop them into the Q&A, or you can pop them into the chat box, whichever is easiest for you. The chat function will only come to me as the panelist, and the Q&A will go to anybody who is asking. We'll just give a quick minute or so to see if anyone types anything in. Okay. Well, it looks like there are no questions in the chat box, which is great. If you want to keep up with more trainings, we do free trainings every single month on a lot of different topics. We also share blogs on different things that are going on in the state, different legal things. Our YouTube channel shares a quick Q&A of HR related questions in 3 minutes or less on average. So feel free to follow us through our social, call us if you have any questions, and then of course, email us if you have any questions. We hope this training has been helpful for you and has helped answer questions, help you have a little bit more information on what Family Medical Leave Act is. But of course, if you have more questions or anything else after this training that you maybe will remember that you didn't put into the question and answer box, please feel free to email us. Thank you so much for attending.